everyone. Today we'll just start about labor relations. So what is this? The labor relations is a study and practice of managing unionized employment situations that bring about good and healthy relation between the two partners in industry, labor and management. The employer and employees themselves must deal with their problems in a manner that mutually suits them best. In short, the labor relations is a function that gives a further connection between the employer and the employees. The interparty character of labor relations is the reason the policy prefers voluntary, so instead of compulsory modes of dispute settlement. We now proceed with NLRC, or the National Labor Relations Commission. It is a quasi-judicial body tasked to promote and maintain industrial peace by resolving labor and management disputes involving both local and overseas workers through compulsory arbitration and alternative modes of dispute resolution. It is actually an attached to the Department of Labor and Employment for program and policy coordination. Meanwhile, as it is attached, it is independent from DOLE. Actually, it started back to the Commonwealth period when the Contract Labor Law Act was passed in U.S. Congress dated January 23, 1885 and was implemented in the Philippines on June 6, 1989. It provides more expeditious and less tied to technical rules than the regular courts. Most labor cases involve poor workers, most of whom perhaps survive on hand-to-mouth wage and can hardly afford the lawyer's services. Having said that, now, what are the rules govern proceedings before the Labor Arbiters and the NLRC? It covers the 2011 NLRC Rules of Procedure and suppletorily the Rules of Court. What is the nature of the proceedings before the Labor Arbiter? We say that as you give proceedings for LA, it is non-litigious, meaning it is subject to requirements of still due process, the right to be heard and to present evidence. However, the technicalities of law and procedure in the regular courts do not apply in labor arbitration proceedings. The next question is, who may file complaints? Any legitimate union, employer, or employee may file a case with NLRC. There are various jurisdictions of the regional arbitration branches. The Fair Labor Practices, that's one. 2 is termination disputes. 3, if accompanied with a claim for reinstatement, those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment. Next is the claims for actual, moral, exemplary, and other forms of damages arising from employer to employee relations. Cases arising from any violation of Article 264 of the Labor Code as amended, including questions involving the legality of strikes and lockouts. So, for letter E, it involves those prohibited activities for strike and lockouts or of that of the labor organizations. Except claims for employees' compensation not included in the next succeeding paragraph. Social Security. So, hindi siya kasali. Medicare, maternity benefits, and other claims arising from employer-employee relations, including those of persons in domestic or household service involving an amount exceeding 5,000 pesos, whether or not accompanied with a claim for reinstatement. So, hindi kasama ang employees' compensation because it's being heard by the ECC. But, kasama ang ilan sa ating mga benefits ay maternity, for other employer-employee relations na hindi mag-exceed 5,000 pesos. So far, do you have any questions?